This is part 2 of the story about courthouse corruption happening throughout the state of Indiana. This episode focuses specifically upon the proven perjury which was committed in the courtroom by a corporation and the judge who ignored it. This perjury was directly related to legal fees, which have been overcharged by a factor of 4 to 1 to thousands of Indiana citizens this year. The same judge who ignored this perjury is the one who is enforcing these overcharged legal fees. Let's take a look at how this all works. This debt collector is able to file easy cookie-cutter lawsuits in mass for small medical debts. Each batch includes up to 100 back-to-back lawsuits for the same medical contract. The work required to prepare these lawsuits is automated and easy. On July 23rd, this company was able to submit over 90 lawsuits, all to be tried within a 3-hour time period in court, because over 80% of these debtors will have no trial, and the remaining 20% will have no lawyer, with very few exceptions. For nearly all cases, the prosecuting attorney receives no opposition from the citizens, as small claims lawsuits can be filed by any ordinary citizen. This demonstrates that the attorney's skill set required for doing this work is minimal, and therefore high-paid senior attorney fees are not appropriate for this task. Yet in some cases, exorbitant attorney fees are being forced upon thousands of Indiana citizens each year. Many recent court transcripts have shown that $200 an hour seems to be the typical hourly rate approved by judges across the country for small claims attorney fees. Yet on that July 23rd court date, this collector charged citizens over $32,000 in legal fees for a 3-hour court time slot. This is absurd. This collector has demonstrated the ability to prepare and file 600 lawsuits per month, repeatedly, all done by a single attorney and her 2 assistants. That's an average of about 1 lawsuit every 18 minutes for every single working hour of every single working day for 3 months in a row. Yet they charge citizens a non-negotiable $375 legal fee per lawsuit, even if the debt is paid before the court hearing. This fee equates to an hourly rate of about $1,300 per hour for this team, and almost $900 an hour for the junior attorney who graduated from Indiana University Law School just 7 years ago. These overpriced fees have been charged non-stop to Indiana citizens for nearly every work hour of every workday for 3 months in a row. And the judge is forcing citizens to pay these overpriced fees. This fee permits this team to charge Indiana citizens almost $250,000 every month, which equates to $2.7 million a year. All prepared by a single attorney and her 2 assistants. Now let's examine the labor costs associated with these attorney fees. The combined wages for this team of 3 is estimated to be under $15,000 per month. This estimate is based upon published salary statistics for the local area. Based upon the collector's self-declared hourly rates, the reasonable charge for this team should only be about $62,000 per month. But this collector has been charging Indiana citizens a rate of almost 4 times their self-declared reasonable rate, and is extorting unfair profits from thousands of Indiana citizens. And these unfair profits are enforced by the judge. This needs to be stopped. Now let's examine how this collector justified their $375 fee to the court. They did it with a sworn affidavit, which swears that their legal team spent an average of 3.5 hours of labor preparing each lawsuit, and that most of this work was done by lower-paid legal assistants, whose blended hourly rate equates to $109 per hour, which multiplies out to justify their $375 fee. And this affidavit was submitted to the court by their attorney as sworn testimony, punishable by perjury. But this affidavit lies. Their 3.5-hour claim violates 5th grade math by a factor of 4 to 1, as their demonstrated ability to file 600 lawsuits per month proves this perjury. Basic division for this scenario proves that each lawsuit actually requires no more than 54 minutes of work on average. And multiplication proves that it would have taken them 4 calendar months to complete the 2,100 hours of work required to prepare these 600 lawsuits. Yet this team of 3 completed almost 600 lawsuits in the single month of June. Here is a view of the perjured affidavit, which declares itself as punishable by perjury, and also declares that the 3.5 hours of work was all done prior to the filing of each lawsuit. These charges do not include any time spent after the filing of each lawsuit, which means prosecution time is not included here. This is done on purpose because when citizens call to settle their debts prior to the court date, no legal fee discounts are granted. They are declared non-negotiable. I recorded my own phone call with the collector as evidence of their strict no legal fee discount policy. Here is a spliced snippet from this phone call demonstrating their strict policy of non-discounted legal fees, even if you pay the debt in full before your court hearing. $375 attorney fee. How is that considered reasonable if I were to pay out of court?
That is our standard fee for filing suit in court.
Is there any reason why the $375 fee isn't less for not taking it to court?
We're not allowed to take that off.
Here is another page from the sworn affidavit, which names the 3 specific staff members who conducted this work, and details the work breakdown, claiming that an average of 3.5 hours of work was done prior to the filing of each lawsuit. As has been shown by simple 5th grade math, this 3.5-hour claim is impossibly overestimated. This is blatant perjury by a factor of 4 to 1. As additional proof of this team's productivity, here we have an official response from the collector provided to the Consumer Financial Protection Bureau in defense of their $375 fee. Here the collector admits to their ability to prepare 600 lawsuits per month using only these 3 staff members. But the collector didn't realize their own math fallacy. Their stated monthly productivity would only allow for a maximum of 48 minutes per lawsuit, even if this team of 3 achieved an actual 100% utilization. This documented statement affirms that their 3.5-hour claim is perjury. But we don't have to take their word for it, as this productivity was already proven by public courthouse records. DocsPomp.com provides courthouse records to the public and readily reveals 538 known lawsuits submitted by this collector in the month of June. There may be additional lawsuits which simply weren't found in our search, but these 538 are established fact. And DocsPomp reveals for this collector over 1,700 known lawsuits submitted during the 3-month period from May through July. This data demonstrates that this team of 3 is able to submit an average of almost 600 lawsuits per month continuously. Here, simple division reveals that each lawsuit must have taken an average of about 54 minutes. Even if this team was actually working at 100% utilization on this task continuously for 3 months in a row. This productivity across these 3 months further confirms that the sworn 3.5-hour claim is perjury by a factor of 4 to 1. Here is a graphical view of this lie for the single month of June. In June, there were exactly 4 work weeks, which only permits for a total of 480 work hours for this team of 3. During this month of June, this team charged Indiana citizens for 1,900 hours of their time, which is about 4 times the amount actually worked. And now let's look at the 3-month graphical view covering May through July. This team of 3 only had 1,600 work hours available for these 3 months. Yet they consistently overcharged for their time by a factor of about 4 to 1. For these 3 months, they charged citizens the equivalent of an entire year's worth of work for this team of 3. It is important to note that this calculation assumes 100% utilization of the 3 team members and ignores inefficiencies, time off, and other distractions. These realistic distractions and inefficiencies would further reduce the actual hours available for this team to work on the preparation of lawsuits. One very significant known distraction is shown here. For these 3 months, for this company, public record indicates over 700 lawsuits prosecuted and closed across 11 different counties on 27 different dates. The travel time alone for this work is estimated at 60 hours. The total time required to handle these 700 cases is estimated to be over 150 hours. This data table, compiled from public record, was used to estimate the travel time and total work time required for these court actions. The total travel time for these 27 road trips is estimated to be 60 hours. Here is the part of their affidavit which describes the amount of time it takes for closing these 700 suits. Using a conservative estimate of just over 7 minutes per lawsuit, results in a workload of 150 hours total, including the travel time. This equates to almost 10% of the total hours available to this team of 3 during these 3 months. This distraction alone only allows for a maximum team utilization of 90% applied to the preparation of lawsuits. Now consider the reality of additional distractions and inefficiencies which are typical of most companies. It is reasonable to assume a minimum of 10% in additional inefficiencies as follows. Status meetings, company events, and other overhead, 25 minutes per week average. Other competing work objectives, 25 minutes per week average. Vacations and sick days, 5 days per year average. Interviewing and training new hires, of which the legal department had 2 during these 3 months, 50 minutes per week average. Responding to customer complaints, 25 minutes per week average. Bottlenecks in team workflow may consume 50 minutes per week average. Personal texting, emails, and phone calls, 25 minutes per week average. Add up these very conservative estimates and you get an additional 10% of overhead, which are hours not chargeable to the client. Combining this with the distraction of 27 known court dates, this brings us down to a more realistic 80% utilization for the preparation of lawsuits. So if we assumed a more realistic 80% utilization of the team resources, the resulting overcharge would become almost a 5-to-1 ratio. Now let's examine some additional proof of this perjury. Let's first look at some comparative proof where a competing collector has proven that lawsuits can actually be filed for a much lower attorney fee. Allied Collections has only been charging $100 per lawsuit, as shown by these court cases filed earlier this year. This collector is known for its ethical behavior and therefore only charges truly reasonable attorney fees. This collector has been in business for over 40 years. Despite charging these much lower fees, this collector acquired a new, larger building this year. Clearly, these fees charged by this collector are reasonable, otherwise they would have gone out of business by now. This collector has set the ethical bar and has proven that $100 is a viable attorney fee for small claims. Meanwhile, unethical collectors in Indiana are charging 4 times this amount for the same type of work, and this is absurd. Now let's examine the proof that their preparation for these cookie-cutter lawsuits is a speedy process. The purpose of this proof is to show that the 3 months of work performed was sufficiently contained within the 3 months analyzed. The database used by this collector specifies the key dates, which proves this to be a speedy process. For my case, the preparation process was completed quickly within a 13-day time period. These records can be subpoenaed for all 3,000 lawsuits filed this year to further establish that this preparations work is a speedy process. In this quotation taken from the collector's filed response, the productivity of this team is measured in a clean, monthly fashion, which further indicates that their preparations process has a short cycle. Now let's examine the proof that all, or nearly all, of this preparation work was performed by the three specified resources. The roster of the collector's legal staff is already known, and there was not anyone else who would have accomplished this work during the 3 months analyzed for perjury. The sworn affidavit claims that the 3.5 hours of work was accomplished by only these three named resources. To ensure that this applied to all other lawsuits filed during these 3 months, dozens of spot checks were made at various courthouses where the lawsuits were also filed. These spot checks confirmed that this same attorney, in fact, filed nearly 100% of these lawsuits filed during the 3 months analyzed. The perjured affidavit submitted locally appears to have also been submitted to at least one other county court during this same time period, demonstrating that this affidavit applies equally to the lawsuits filed in other counties for this same creditor. Additionally, the collector's filed response clearly admits that nearly all of the preparations work was accomplished by these three team members. Here is a roster for the legal department staff members as of June 1st of 2013. The first three listed are the same three resources listed on the affidavit. Then by July 1st, this collector hired another senior attorney to serve in an executive role. And by the middle of July, the collector hired Dustin, a second junior attorney, for the purposes of assisting with the handling of these lawsuits. But for the majority of July, it appears that Dustin was undergoing considerable training before being permitted to handle lawsuits without supervision. Evidence indicates that Kimberly spent considerable time training Dustin during the month of July to prepare him for doing his work solo starting in August. Yet while this hiring and training occurred, the collector was still able to file a record-breaking 832 lawsuits in July, while still attending about a dozen court dates and closing out hundreds of other existing lawsuits. Now let's take a look at the actual lawsuit deliverables. This collector sues hundreds of patients, all for the same clean, single-page emergency room contract. The verbiage of this contract only needs to be reviewed once. Otherwise, the paralegal only needs to validate the signature and date on each contract, and also does a few other lookups and checks, easily automated by software and online databases. The entire court summons only contains 3 easy signatures. The rest of it appears to be a computer-generated form, inserting the appropriate information which already existed in their database for each account. This court summons appears to have required only about 15 minutes of preparations work. This collector's creditor scheme is very simple. In 2013, this collector submitted about 3,000 lawsuits, all for one of the 5 ER physician groups whom they represent. Yet all of these physician groups share the same business office. This business office behaves as a singular creditor for all 3,000 lawsuits. This scheme permits the collector to perform efficient batched processing, which enables high productivity. Yet despite these ideal conditions and the efficiency of having an internal legal department, this collector still charges almost 4 times the legal fee of a competing collector. To confirm the accusations and theories presented in this video, we suggest the following subpoenas and supplemental information gathering. Subpoena the work contract for each legal staff member, as well as any evidence of overtime, sick days, vacation, or other time off. The purpose here is to confirm the assumption that each team member worked an average of about 40 hours per week. Also subpoena the information about the 27 or more court dates to which the lawyer traveled, as well as who came along with her. For each trip, how much time was spent out of the office. The purpose here is to quantify the total time spent on this distraction, which subtracts from the time allocated for the preparation of new lawsuits. We suggest to also subpoena the raw data from the operating system specified in the affidavit, which shows vital details and dates for each account, and also includes timestamps and names for those who worked on each account. The purpose here is to further affirm the conclusion that this preparations process has a short cycle which fits cleanly within a month. It also clarifies the resources who spent time on the preparations for all 1,700 lawsuits filed during these 3 months. A subpoena for the evidence that legal fees are not discounted for those who settle before the court date establishes the motivation for why their affidavit declares the $375 worth of legal work being done all prior to the filing of each lawsuit. For about a dozen cases which I have polled already, there was no legal fee discount granted for settling the account before the court hearing. Subpoena testimony and evidence of other work done by Jennifer Perky, the bill collector, from May to July, which was not a part of the specified preparations work. This may affirm the theory that Jennifer Perky was not working only on the preparation of new lawsuits during these 3 months. Obtain the testimony for who authored the sworn affidavit and how the 3.5-hour work estimate was determined. When was this affidavit authored and by whom, and from what were the supporting statements derived? The purpose here is to clarify the suspected motives behind the false claims made within this affidavit. Subpoena information regarding the scope of this affidavit by discovering which courthouses have already received an equivalent affidavit for this same creditor. Our evidence indicates that over 3,000 lawsuits have been filed in Indiana during 2013 on behalf of the same creditor, Professional Medical Billing. Obtain testimony and evidence regarding Dustin Allen's employment in July, including his start date, new hire procedures, and the training received during the entire month of July. Determine the number of lawsuits he prepared without supervision during July and the date of his first unsupervised court date. Evidence gathered so far indicates that Dustin received extensive training in July and was not a productive contributor until the month of August. Our theory is that Dustin's involvement in July was net zero at best, or very close to it. We recommend that the following individuals be interviewed for their testimony on this matter. All of these people are, or were, employees of the collector during the 3 analyzed months. The purpose of these subpoenas and investigations is to confirm the following accusations and theories. Number 1, the 3 named resources did all, or nearly all, of the work described by the affidavit. Number 2, the named resources worked about 40 hours per week for the months of May through July. Number 3, these resources had measurable distractions which detracted from their time spent on the preparations work specified in the affidavit. Number 4, this preparations process has a short cycle, usually accomplished within a few weeks. Number 5, the erroneous 3.5-hour claim was perjured, with the predetermined objective of justifying the $375 fee, rather than with the motive of presenting an honest and factual work estimate. Before ending this video, I'd like to announce the following disclaimers. I, Brian Knox, am not a lawyer. The conclusions presented here are personal, based on information I have compiled from personal and public information sources. I have invested over 200 hours of my time into the research and presenting of this information. The information and conclusions that I am presenting here are truthful to the best of my ability, although some degree of error is likely. Accusations of crime and misconduct that I have made in this video are personal opinion based on the evidence that I have compiled. The accusations of perjury have not yet been prosecuted. My implication of judicial misconduct has not yet been investigated. Court officials and those with governmental power may end up not agreeing with the conclusions that I have made in this video. Thank you for your kind attention. I hope you found this video informative and inspiring.